This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Welcome to this international edition of Ask a Lawyer. International, how do I know? Because I see there's somebody watching from Jupiter. Ba-dum-bum.
Oh.
Anyway, I'm Stuart Address.
That's bad.
I know, but it's true. I'm Stuart Address, and this is Ask a Lawyer. And I'm here to chat with you about some legal issues. I'm also here to answer your questions, which I'd prefer to do, actually. Otherwise, I just talk and talk and talk, and I do that all the time.
I got a question for you.
You got a question for me?
All right. I go to Disney World,
Hey.
and I get hit with a bird.
Oh, this is a real story.
This is the lead story yesterday.
I know.
And they're suing Disney because she's got brain damage? Are you kidding me?
That is an absurd, frivolous lawsuit, in my opinion. Disney cannot control birds. Now, if it was an animatronic bird, that's another story. But if it's a live bird, you know, you do accept some risks in life, and being hit by a bird may be one of them, whether it's a Disney bird or a bird in front of my front yard. So, I read that story too, and, you know, again, here's the problem. We read a story, we don't really know all the facts. If there are facts that we don't know that are material, it may not be such an absurd thing. Just like the McDonald's coffee case. I always go back there. But if the facts are generally what have been reported, then it's what gives lawyers a bad name because it is the epitome of a frivolous lawsuit.
Well, you just brought up something now. An animatronic bird. I mean, you know, they've got them all over the park. I mean, I never even thought of that.
Well, that's why I get paid the big bucks.
Oh, my God.
You know. Yes, if it was an animatronic bird, I think then, I was going to make a Trump joke, but I won't. All right, so I thought today I would chat a little bit about 3 cases in my office over the past couple of weeks, and see if we have any lessons that we can impart to everybody who may be listening, and friends, family, Romans, and countrymen who you may be able to impart it to. And the first one is a case which was settled just this week at a mediation with the EEOC, the Equal Employment Opportunity Commission in West Palm Beach. Now, I happen to have been amazed that the EEOC did its job, and that is not a knock on the EEOC. It is a knock on every presidential administration since Bill Clinton that has gutted the budget and gutted the staff of the EEOC, so that when you file a charge of discrimination, whether it's gender, race, age, national origin, disability, sexual harassment, retaliation, what is supposed to happen and what used to happen very early in my career is it immediately went to an investigator. The investigator made contact with the complainant or the complainant's attorney, me, then sent the complaint to the employer. Employer had to respond to it. We got a chance to reply. And then the EEOC would either offer mediation or issue a right to sue letter, which had the traditional 3 boxes. We believe there's reason, we have reason to believe discrimination occurred. We do not have reason to believe discrimination occurred. We can't figure it out. And unlike today, back then, one of the first 2 boxes were very often checked because the EEOC did its job. It investigated. talk to witnesses. That doesn't happen now unless you may be 5,000 women suing Walmart. Then the EEOC investigates. Most of the time now, we cannot find an investigator. We can't find out who it's been assigned to. We can't get a hold of the person when we do find out. We can't get them to call us back. It takes forever for them to send charges to the employer, to make the employer respond, and they don't investigate.
Do they have investigators, or are they using PIs?
No, they have investigators, but I will tell you this. In the last 10 years, for all the charges of discrimination I've filed that all go to the Miami office, I have been assigned to the same investigator in 90% of the time. That tells me there aren't very many of them there. And that is the problem. So when I say I'm shocked that the EEOC did its job, it is not a knock on the EEOC. It's a knock on our legislative and executive branches of government that don't sufficiently fund it to allow it to do its real job, which it used to do. But this time, an investigator was assigned. Ultimately, it asked the employer and the employee whether it would be willing to engage in voluntary mediation. Everybody said yes. And lo and behold, I had a mediation before the EEOC earlier this week, which is a little bit different than normal mediations in that it tends not to last as long.
Is it in a courtroom or an office?
Oh, no, it's in their office building.
Okay,
And
okay.
you know, for everybody who doesn't really know, let me give you the quick and dirty on a mediation. Y'all start out in a conference room, all of you. And the mediator gives a standard, what I call a mediator spiel, which is you're all here voluntarily. You've all chosen to mediate this matter. I'm a mediator. I don't decide anything. I can't order anything. The only reason I'm here is to try to help the two of you come to a decision that you're both willing to live with. And both parties' attorneys give a little speech. Sometimes it's pleasant, sometimes it's antagonistic. And then we separate into two rooms. And the mediator engages in what they used to call shuttle diplomacy. You know, during when Kissinger coined the term, when he was going between the Israelis and the Arabs, trying to negotiate peace, he kept going from, one capital to the other as shuttle diplomacy. So the mediator engages in shuttle diplomacy and takes numbers back and forth. A good mediator not only takes your numbers back and forth, but if you're the one who wants money, he tells you the worst parts of your case to get you to lower your demand. When he's with the other side, he tells them the worst parts of their case to get them to increase the number. He never comes in and tells you how wonderful your case is, because then why will you move? They focus on the weaknesses to get you to realize nothing's a slam dunk, especially if you go in front of 6 people in a jury maybe 2 years from now. And so good mediators have techniques to try to bring you closer together. Now, what happened earlier this week? This was a disability discrimination matter. I won't give names or companies because actually, since we settled, I'm under a confidentiality agreement. But what I will say is this involved a driver for a company that delivered food who would park in the handicap spot in front of the store because he had a handicap and he had a handicap placard. And he was told, you can't park there. That's for the customers. Go park way, way, way. Now, I can understand the ordinary employee of a store, especially in these strip malls, being told, you don't park up close. You go park way in the boonies. These are parking spots for customers.
So he would be there a length of time.
Right. However, when the government has seen fit to give you special permission to park in a designated space, the employer, in my view, cannot tell you can't park there.
So he had the placard.
He had the placard.
And it was current.
Yeah, yeah.
Wow.
And he complained to his superior and was given a hassle. That wasn't the only instance he complained of. He had a disability which impacted his ability to walk. He walked with a limp. He was made fun of. He had a disability where one of his hands, the fingers are sort of curled up, and he was talked to as if he had dinosaur hands. And there were other things.
Wait a minute. Employees referred to
Managers, employees.
Are you kidding?
No, this is not. This
The
is
hell kind of place
This
is
didn't.
that?
You think this is unusual?
Yeah.
This is how I spend a third of my day. I mean, come on. Sexual harassment, gender discrimination, race discrimination, disability. Why is there so much of this stuff? Because people are, as I like to say, stupid. There are still too many stupid people out there who think they can do these things. And when that stops, I'll have to find another practice area because I won't be able to make much money. So the good thing about what he did was not only did he complain verbally, on a couple of occasions he put it in writing. Oh my goodness, that means the world. You'll find out why that means the world when I tell you story number 3. Okay, this is story number 1. And ultimately, before he ever even hired an attorney, he contacted the EEOC and he filed a charge of discrimination. When they offered him mediation, he decided he'd better call an attorney. And that's when I stepped in. So we went to mediation, and the decision is, well, do you want to negotiate non-monetary terms where they're not going to do this anymore, and a smaller monetary amount where he's going to stay employed? Or do you want to negotiate a separation of employment and a larger monetary amount? Now, there are situations in which employees, my clients, say, I want to keep working here. Okay. You run a lot of risks if you do that, in my view, because they might come up with a baloney, legitimate, non-discriminatory reason to terminate you 3 weeks later. And now you have another lawsuit on your hands. So you don't want to go buy a lawsuit in settling a lawsuit.
Yeah, but it sounded like a pretty hostile work environment.
Yes, and when it gets to be like that, the best thing to do is negotiate a resignation and a separation of employment. And they wanted to negotiate, well, he'd stay working there because they'd pay less money. And when the EEOC mediator came back and explained that to us, I said, no. That ain't happening. If that's the way it works, we're leaving right now. We're here to negotiate a separation of employment. And that is the way we then proceeded. Now, after 4.5 hours of what was supposed to be about a 2-hour mediation, we did settle. Now, I've always said this, and in fact, this a mediator from mediation I had the day before actually had a little card on him. I don't have it with me right now. But it said essentially what I've always told my clients. A good settlement at mediation is one in which both sides can live with the result, but walk out a little bit PO'd. If you're going to win a Grand Slam home run, the other side's not going to agree. Now, you might get that Grand Slam if you want to go to a jury trial, but if you're going to settle a case, you got to be realistic. And so my client accepted less than he wanted. And let me tell you, the other side paid more than they wanted because every time they kept trying to go up by $1,000 or this is our last offer. You know, I turned to the EEOC mediator and I'd laugh. I'd say, I don't believe that till I hear it 3 times. You know, click your heels 3 times. So I would counter their last offer and they'd go up again. Tell us it's their last offer. I'd counter that last offer. They went up again. It's our last offer. The next time I was told twice, that was it, we're not moving. I then got them to go up another $500. Now, what's $500? $500 isn't much if you're settling for $100,000. $500 may be a lot if it's a smaller settlement. And depending upon the type of job you have and how much you earn, it may be. So we at least extracted the extra money from them. And that just goes to show that negotiating is also an art. It's not a science. You have to figure out when to say yes and when to bluff and when to push and when it might backfire on your client. And you have to discuss that with the client before you do it, because they're the ones that run the risk that if you as the attorney make the wrong choice, the other side walks out, what they could have had is now lost.
They're toast, yes.
Right. And so, these are the discussions, and this is why mediations take so long. You have to explain pros and cons each time around to the client, give your recommendation, and let the client make the decision. And when the client says, I'll do whatever you want, as an attorney, you've got to say no. Now, some don't, but you cannot make the decision. The decision must be made by the client. An attorney can make decisions on strategy, things like that. But when it comes to settlement negotiations, demand whatever you think is fair. No. I'll tell you the range of what I think. I'll give you my recommendation. But you've got to say yes or no. You can't just say, I'll leave it to you.
So if your client's really wishy-washy, you can't just say, this is what it really needs to be?
Yes, you can, but then they have to say okay.
But they have to, okay, yeah, I got you.
They've got to say okay. You can't just do it on your own. You have no authority to do it on your own ethically. So, all right, so we settled here. The moral that I want to convey is put it in writing. Oh, my goodness, folks. When you call up Cheryl at 781-8003 and you talk to her about a potential case, and she asks you, well, did you put any of your complaints in writing? And you say no. And then she comes to talk to me about the phone call that she had with you. And I say, did they put any of their complaints in writing? And she says, no. I groan. Because you're making it a he said, she said. No lawyer wants to take a contingency case and take 2 years and go to possibly a jury trial on he said, she said. We want evidence. We want witnesses. If we can't have witnesses this early in the game, we at least want you to have done the best you can and put your complaints in writing, email, fax, whatever, so that they can't come back and say, as they inevitably do, well, we never knew this. I'm telling you, that is the employer's response. Inevitable. If you don't put it in writing, I didn't know. He, she never complained. And now you've got to defend against that. Put it in writing.
But it could take as long as 2 years?
But once you file suit in federal court, 18 months to 30 months for an average civil case.
Oh, my gosh.
I have a case right now that's 8 years old. Oh, yes. And that's another reason a mediator says to you, especially if you decide to have pre-suit mediation before you've even filed. You could settle now for X, assuming you can get a reasonable X. Or you could take your chances and go for Y, but you're going to go through the entire litigation process, discovery, motions, court hearings, and then maybe get to trial in a couple of years, get a decision, then the other side might appeal. So if you get to something that is reasonable, my recommendation to my clients is to settle. Now, I don't tell them to settle at an unreasonably low number, but I tell them that if we get into what I call the window of opportunity, windows open, windows closed. We come in with a predetermined range. Let's say I'm thinking this case should settle right now, pre-suit, somewhere between $20,000 and $40,000. The window opens when they hit 20. If that's all they'll do, I'll still say to my client, settle. We're in that range. We're at the very low end, but that window's open. We're in that range. Now, if I can get them up to 37.5, we're now at the higher range of our window. That's a pretty good settlement. Now, I don't know what their range was on the other side, but I'm evaluating the case the way I evaluate the case. It is very rare that you walk out of mediation thrilled. Like I said, usually you have to be grudgingly accepting.
Okay, your case, it's 8 years old. How many man hours do you have in that?
Well, I'm lawyer number 4.
Oh, God. Oh.
And the lawyer on the other side has
no.
delayed.
Oh.
So it's my job to get this thing to trial.
Oh, brother.
Yeah. All right, so you got to try to figure out a rational number, and you work with your client to do that. And if you get within the range, the recommendation really, from me, is to settle. What happens if you get just under that range? Now it's a tougher call. Now the client has to decide, can I really live with this, or do I want to embark on the next phase? Sometimes it's a good idea just to live with it. Sometimes it's a better idea to embark on the next phase, because sometimes if you actually file suit and they realize you're serious, all of a sudden they're willing to offer more money. So it's a case-by-case decision and a client-by-client decision. If I have a client who is very anxious and is going to be stressed every time they get an email from me, if we get close to a decent amount, settle the case for your own best interests, for your own mental health, your own physical health. Settle the case. If we have a client who can handle this, handle the stress, the anxiety, the time, well, then you might push a little bit longer. So it really is individualistic. Now, I said very rarely do you get a case where, in mediation at least, your client walks out thrilled. Hey, folks, 340-1590, I'm doing a monologue. It's like Shakespeare. To be or not to be? That is the question. Whether you will call me and force me to talk. That's much better.
Yeah, but that's a fascinating case that you just talked about.
I know. Sometimes I hear people don't call because they like the stories.
Yeah,
But that's
well,
okay.
no, they don't want to
That's all
interrupt
right.
you. That's what the deal is.
If you don't do that, then call Cheryl. Cheryl will talk to you initially, and then we'll talk together.
All right, what's
All right.
number 2?
All right. Well, wait a second. Finish number 1.
Uh-oh.
Sometimes you do get a case where you hit a home run, and you have not accurately valued the case before mediation, for whatever reason. You may not know a worry the other side has. I had a sexual harassment case a couple of years ago where I said to the client, this would be a reasonable range for settlement. In my view, this is a home run. And this would be a grand slam. And we're not going to get there. We go into mediation. We make our first demand, which is outrageous, designed for negotiating leverage. And they come back with their first offer. And it's our grand slam number. And I play poker face. That's absolutely ridiculous. I tell the mediator. What are they, crazy? Because inside I'm jumping for joy. I don't understand, but I'm jumping for joy. But I'm not letting anybody know that. And I've warned my client, no matter what you hear, your facial expression is blank, like you're a zombie. We'll talk privately, and you can let me know how you feel. So the mediator leaves to let us talk. And I said to her, okay, look, something's going on over there. There's something they don't want known, because you just got a better offer than I imagined you could ever possibly get at the first number. And, we're here for 8 hours. So we figured that based upon the nature of this particular sexual harassment case, the person who she was alleging sexual harassment against absolutely did not want it made public. The confidentiality was an absolute consideration of their part. So we changed our negotiating strategy in terms of our numbers. And when we went down our number, the idea was now to get them from the Grand Slam to, I don't know, there's no such thing in baseball, but okay, 3 Grand Slams in a row. Trifecta. And so we kept negotiating. And I got to tell you, at the end, we settled for a very pretty number. And although we did not let it known while we were in the offices, as we left, We both did a little Irish jig. We were both overjoyed. She was overjoyed at the monetary result, and I was overjoyed at my fee. So there are situations where that happens, but it's not the typical one.
Few and far between.
Yes. All right, so second story. We're going to move now to landlord-tenant court. Okay? And this is not a mediation story, but it's another story where hopefully lessons can be imparted. This is a story where my client ended up with a bad result without an attorney, hired me to try to fix it. We still ended up with a bad result. Okay? Yes, folks, I lost. I believe we could win on appeal, but it's up to the client whether they want to pay for it. So, what's the moral of this story? The moral of this story is when you're served with a summons and complaint, don't ignore it. Don't think it's going to go away. Thanks, Tom. We have a lawyer saying he doesn't have any questions, but he likes it. Yeah, call me one time. Maybe we can even, I can have you as a guest here.
You could do an on-air mediation.
That's right. We do an on-air mediation. He's off to a conference. I can't see the rest of what he wrote, but maybe, who knows? Maybe it's a mediation. So if you get served, don't ignore it, please. You've got, depending upon, in landlord-tenant court, you have 5 days. Normal court, you have 20 days to respond. If you don't respond, a default's going to be entered against you. Now, that, in trial now, weekly. He's loving it. It's not so hard to vacate a default if you do it really quickly. The longer you wait, the harder it is. If that default is converted by the judge into a default judgment, it becomes harder to vacate and fix.
So this is a landlord filing against a tenant?
Yes.
Okay. Gotcha.
If a writ of possession is issued in landlord-tenant court to the sheriff to throw you out, chances are you're not going to fix it before you're thrown out. Don't ignore a summons and complaint. And if you claim that you were never served, and you want to know something, it does happen. Now, sometimes people call me and they say it, and it's really not true. But sometimes it is true. So I have to start by giving them the benefit of the doubt.
What, they served the wrong person?
Serve the wrong person.
Are you serious?
Oh, yeah. The law says, for example, if you're gonna do personal service, you can serve anybody that resides in that house that's above age 14. What if you serve somebody and they don't live there? You're not served. Now, the process server doesn't know that. The process server is going to go back and execute a return of service that you've been properly served by what's called substitute service.
But doesn't the process server automatically say, are you so-and-so?
No, I'm not. Do you live here? Yes. Let's say that's a lie.
Okay.
You're older than 14? Yes, you're served.
Wow.
That's legal service if you live there. If you don't live there, it's not legal service. If you're under 14, it's not legal service. So there are other situations, let's say posting. There are certain situations in which posting on your door is proper service. Well, sometimes the wind blows it away, for real. And you were never served, and all of a sudden there's a default entered. Let me tell you something. When a default is entered, chances are you're going to find out about it, even if you haven't been served. If you do something about it immediately. Don't wait. So let me tell you a little bit about what happened in this case and why it went south, in my view. The client was provably in the hospital at the time of service. Somebody answered the door and said, yeah, I live here. Got served. Later on, it turns out that that person or another person the next day, there was a burglar. And the sheriff was called and arrested somebody for burglary. Now, the name of the person who was the burglar and the name of the person who was served were remarkably similar, not identical, but similar. So my operating theory, without proof, but my operating theory, was that the burglar was the person served the day before. Now, of course, the landlord says, well, there's no evidence of that, and this person said that they lived there, and, okay, that's the landlord's, argument. And we go in on a motion to vacate the default judgment, the writ of possession, which had already been executed. He's out of this house. And to undo everything, which is pretty hard. And I figure, well, we got a decent chance because we could prove he was in the hospital. And we can prove that the property manager knew he was in the hospital.
Ooh.
Yeah.
That changes the whole ball game.
Now, what does the property manager testify to? I called him on the date of service, and I told him he had been served. My client denies it. Now it's he said, she said, or he said, he said. If he knew about the service, does that make it good service? No. But if he knew about the service, now depending upon the passage of time between the service and the motion to vacate, the court can utilize its discretion to determine whether there's good cause. When you wait 6 months to challenge the service, judge is a little bit pissy. Especially when it's the judge whose orders you're asking him to reverse. Not some other judge who's looking at it dispassionately, but the very judge who entered these orders, and you're saying he was defrauded by the landlord's representative and was duped. And now you need to reverse your default judgment, and your writ of possession. And then the judge says to me at the hearing, and let's say I agree with you. And let's say I'm willing to enter that relief. How do I put the parties back in what's called the status quo before service of process? How do I put them back into a house that's already been rented? How do I make this right? Well, that's a tough issue, isn't it? Because if the judge can't give you the relief you're seeking, he really can't give you the relief. So we had a good hour and a half hearing, and by all of the judge's questions of me and of the other attorney, I thought we were definitely going to win, and he was going to vacate everything. That goes to prove what all lawyers, good lawyers, will tell you, especially in appellate court. Don't ever think that because of the way a judge asks a question that he's on your side. In the Supreme Court, these justices are known for asking questions that go against the very position they're going to take to get information, to test your case. It doesn't mean that's where they're coming from. So I really, in this situation, the whole hearing was hostile to the landlord. And I believe that the end result was going to be we were going to prevail.
You had a slam dunk case.
Well, at the very end, the judge starts giving his opinion, says that he believes that the landlord's representative, the property manager, is credible, believes that he told my client in the hospital that he had been served, that my client had waited an inordinate amount of time to seek to vacate, and that therefore court was not going to vacate. Denied. And my client lost. Twice. Once because he did nothing, and once with me, because he waited a very long period of time. Now, I did advise him about the possibilities of appeal, pro and con. And I told him there were certain matters, certain aspects that I thought he had a decent appeal. Now, from landlord-tenant court, which is a county judge, you appeal to the circuit court. I thought another judge, and I knew who the judge would be because there's only one circuit civil judge, that handles this stuff. I thought we can get a fair hearing and maybe reverse it. But I also warned the client, because it costs money, you have an uphill battle because of how long you waited. And that's one of the reasons that this judge says he decided how he did. And this circuit judge may decide to accept that as a legitimate discretionary determination of the court. If so, you lose.
Do they reverse many or no?
It is a fact-sensitive situation when you're arguing facts. And if you're arguing a legal error, then it really comes down to whether you as a lawyer truly believe a legal error was made. I mean, if a legal error was made, it should be reversed. Facts, the trial judge is given the benefit of every doubt. Because supposedly the trial judge is the one who had the parties in front of them. And if you make a credibility determination, very hard for an appellate court to reverse that. Appellate court doesn't see the person.
Yeah.
So that's how a trial judge can insulate themselves, by making credibility determinations. And I do think we have a caller before I go on to story number 3. Hey, Bob, how are you doing?
Hi, Stuart. How you doing?
Good. How can I help you?
Okay, I have got a question. Let's assume that I'm being sued and my opposition, let's just say that everybody presented all the evidence and the judge comes says, I'll give you my decision in a few minutes. He comes out and he says, okay, Mr. So-and-so, it seems to me that you presented a fair, reputable, blah, blah, blah case.
Okay.
Does this automatically mean that the other side is going to win?
No. I don't know why that would mean the other side would win unless the other side presented a better case.
Okay.
So what did he say
Okay.
after that?
Well, then he says to the other side, Mr. So-and-so, you too have presented a fair, equitable, reputable, whatever case. But then he says, and when he says, would that mean that you're going to win?
Well, if he's saying that both of you presented a good case and then he's saying to the other side, but, that may be an indication that the shoe's about to drop on them. But I assume if he said he was going to issue a decision after the but, and whatever the but was, he then issued a decision, or did he say, well, I'm going to write it up later on?
Okay.
Did he issue a decision?
No, I haven't been sued. I'm just talking hypothetically now.
Hypothetically. All right. Hypothetically, if a judge is going to issue a decision immediately after a hearing, and he says to both sides, you both presented good, fair, reasonable cases, and he says to one side, but I suspect the shoe is about to drop on that side. Okay?
Okay.
That's what I would assume. Sometimes the judge means what he says, and sometimes, if you're in small claims court, for example, and you both don't have a lawyer, he doesn't want to try to, most judges, good judges at least, don't want to make a loss even worse for you and tell you how horrible you were in presenting your case. So they may be magnanimous to both of you and then just indicate who wins and why. You can't really tell. Very often, I'll tell you what, when we have a real trial, like a 2-week trial or something, and trial's over, whether it's a jury that's going to come back and give a verdict or whether the judge himself is going to give the verdict, the judge almost invariably says to both sides before it happens, really speaking to the clients, both sides' clients, your attorneys did a phenomenal job presenting this case. You should be proud. You both have excellent attorneys. let me tell you something. I don't smile and take pride in that statement. It doesn't mean anything. It's designed to tell the clients, one of you is about to lose, but don't feel bad. You put up a good fight.
Okay.
Okay?
Okay. All righty.
All right. It's the best I can do for your hypothetical.
Yeah, thanks.
You're welcome. Take care, Bob.
Let's go, Mets.
Let's go, Mets. That's right. You better believe it, buddy. Bye-bye.
And hopefully the hypothetical doesn't become realistic.
All right, so we'll just have time for this third example, which is great. This was a sexual harassment case. And I told you there was going to be a moral that connected the first story to the third story. This was a woman who was complaining that a particular partner in this company, an owner, was constantly making comments to her, brushing up against her, etc. And when she came to us, she had complained to the alleged harasser verbally, "Stop that, don't do that, I don't like it." Had never gone higher. And had never put it in writing.
Well, he was the partner in the company, though.
He was a partner. Doesn't mean if you complain to HR or to one of the other partners that they wouldn't do something about it. That's their legal obligation.
With this person, though, right?
Right.
Okay.
So we say to her, you've got to put something in writing. Otherwise, I can't see taking this case as a trial case. So we actually prepare an email for her, laying out all the instances of alleged sexual harassment and sending it to another one of the owners because she couldn't send it to HR because she was HR.
Oh, no.
Which also meant she should have known to have put it in writing much earlier.
Oh.
So she sends this email, and they hire a law firm to investigate. The law firm investigates, which, not surprising to me, at least they tell me they find no evidence of sexual harassment. Now, normally that's where they make their offer in contrast to our demand. In this situation, they don't make an offer, and no matter what we do, we can't get them to make an offer, which is unusual in a sexual harassment case. And I end up having to say to this client, something's going on here. I don't know what it is, but it concerns me. And the fact that you didn't make a complaint at any of the times that this was going on over the money month period that this was going on really hurts you. And now I am probably not going to pursue this case further and file a lawsuit. Another attorney might, because we now got he said, she said without witnesses. And I can imagine the cross-examination on the witness stand. She's the HR manager. Did you follow your own procedures in the handbook? No. Why not? I don't know the answer to that. Did you put anything in writing? No. Why not? So here's the connection between the first story and the third story before we go to John, who's on line 2. In the disability case that I just mediated this week, he had made 2 complaints in writing. There was evidence he complained and how they handled it or didn't handle it. In this third case, the sexual harassment, she did not put anything in writing. And if they don't want to negotiate, now I have to consider how strong of a case is this on a contingency basis to get into for possibly 2 years and 1,000 hours. Do I want to do this? And so, what is the moral? The moral is what my sister-in-law on Facebook Live is saying. She's saying, I was in HR for many, many years. My common response was always, document, document, document. Folks, that's my moral.
Yeah. She's
Document,
right.
document, document. You don't have to be mean when you're documenting. You don't have to be hostile, antagonistic. If you have an HR department, you send an email to HR saying, I spoke to Bill Smith about him calling me a sexy woman, and he hasn't stopped. Please help me. It's wonderful. If it happens again, document it again. That's great. Because then when you come to somebody like me, if you have to, you're going to have a much stronger position. And if the employer does what the employer is supposed to do, what the Supreme Court says gives the employer immunity from suit, if the employer conducts a reasonable investigation of your complaint and takes prompt remedial action, you may never have to call me.
That would have to be an outside investigation, right?
Well, no. The boss can investigate whether one of the managers did something bad, decide that, yeah, it happened, and I am going to discipline this manager, or I'm going to fire him, or I'm going to transfer him, or I'm going to do something that takes you out of harm's way. That is prompt remedial action. And now, even though you were sexually harassed by this guy, you can't sue the employer. The employer is immune from liability under Farragher versus Boca Raton. Okay? Because they did what they were supposed to do. So the Supreme Court has said to the employer, here's what you got to do. Do it, and you've got immunity. Don't do it, and you can end up in court. All right, so let's go to John on line 2. John, are you still there? John, we got you?
He just fell off.
All right, sorry, John. If you want to call back, we got a couple minutes. If not, I apologize. I just wanted to finish that story. So, let us continue just for a moment with that sexual harassment thing. We talk about prompt remedial action. Very often, somebody gets moved. And the question arises, they moved me. That's not fair. I didn't do anything. Why do I have to go to another store? And I'll tell you, I feel for you. I agree with you. The law is a little bit different, though. Now, if putting you at another store is really going to work a serious hardship on you, they can't do it. Because then they're punishing the innocent victim. They can't do that. That's adverse employment action. If moving you from one store in Port St. Lucie to another store in Port St. Lucie is immaterial, then they can do it. And I will read to you from a case. If I can take my glasses off for a second, because it's in small print. Essentially, there's a case from 2014, and it's essentially the law. And I won't read you the quote. The sum of it is, the courts have concluded that a victim's transfer can be considered a proper remedial measure in a hostile work environment if it is not substantially adverse to the victim. So what they've said is, it's not a per se prohibited method for addressing allegations of sexual harassment. The court will presume that a material adverse transfer would be an unreasonable remedial action, but that conversely, a purely lateral transfer could qualify as reasonable. So what the court's going to look at is, well, let's say one store in Port, now I can't get my glasses on because of the headphones. Give me a second.
Gotcha.
One store in Port St. Lucie is the top performing store in the district, and you get mega loads of commission. And the other store in Port St. Lucie is the dregs of humanity.
Uh-oh.
And you're not going to make any money there. And you get transferred to the other store just a mile away. Matter of fact, it's a mile closer to where you live. It's still adverse employment action because of that opportunity to make the money. But if everything is relatively equal, transferring you a mile is not adverse. We got Tony on line 1, and we got a couple minutes. How you doing, Tony?
Hey, how are you, sir?
I'm good. How can I help you?
Real quick, I was involved into an accident. Basically, I was going through an intersection. A lady hit me. Police came, didn't give any tickets to nobody. About 7-8 months later, I got served in my home. I actually don't remember being served, but they said I did. So I didn't do anything about it. And I wish I would have heard your program before that, because somehow they found me in just cause and sued me for $54,000.
Okay.
Now they literally will take my license. I'm a CDL driver. They will take my license if I don't pay the $54,000.
Right.
I worked out a payment plan, and I'm paying. I paid like $500 down. I'm paying $50 a month for the rest of my life, I guess. My question to you is, I truly don't remember being served.
How long ago was this?
Probably 2017. Maybe, the end of 17.
All right. And how long ago was the judgment entered?
That I don't know, but I could find out. But I mean, I personally don't know.
Yeah,
I'm sure it was sometime in 2016.
All right. The problem is, just like in my first story with not my first story, second story, the landlord-tenant story, you're probably not going to be able to get that vacated.
Right.
Even if you claim you weren't served and you have evidence, it's too long. Plus, the other side may testify. Who knows? The process server may have taken down height, hair color, things like that, and swear, yes, I served the right person.
Yes,
So
sir.
you probably have a very uphill battle, but I would always tell everybody, call a lawyer, talk it out, get more than you can get from me right now, because particularly I only have 1 minute left.
Do you know, I was told by somebody that called me, basically asking me questions, that she sued her mother's homeowner's insurance?
I can't talk.
Does that make any sense to you?
Well, it depends upon whether insurance covered the prohibited action. But
Yeah,
I've got to cut you off, unfortunately, because
Okay.
I got about 30 seconds left. I'm sorry. All right, folks, this has been Ask a Lawyer. Feel free to call Cheryl at 781-8003. Until next week, don't get sued. And if you don't have to, don't sue anybody else. Have a great weekend.
This is WPSL, Port St. Lucie, WPSL.com, worldwide, webcaster to the world, on Alexa and Google Home.